All right, good morning, everybody. Court will resume with the February 9th, 2022 docket. And let me remind everybody that we're on YouTube. And I have, let's see, Miss Logan.
I'm here, Your Honor. Thank you.
Yes, ma'am. Good morning. I'm waiting for Mr. Ramirez. I don't know if you can hear me now.
Yes, Judge, I can hear you. I'm just trying to get my video set up. I'm having trouble with that.
All right. All right. That's great. I believe we're here on CL 21-14-2070, Teresa Sipes versus Elizabeth N. Berger. It's a motion to compel?
Yes, Your Honor. It's the
Your
second
motion? Is it your motion, ma'am?
Yes, it is.
Okay.
It's the second motion to compel discovery responses from Mr. Ramirez.
Okay, discovery responses. And it'll be the second. All right.
Yes.
There's Mr. Ramirez. I saw him. There he is.
Yes, Judge.
All right, Mr. Ramirez, we have a motion to compel responses. Yes, sir. Your response?
Yes, Judge, and I'll let counsel's motion speak for itself. This was previously set for hearing. I had reached out to her the night before, the morning of, and I told her that I'd get the discovery responses to her. They were completed. Just my staff had not gone from point A to point B. That was back in the fall, Judge, and I thought that had been sent out. I've had some staffing issues, and I do not have any staff at the moment due to it being difficult to hire somebody right now. I've been extremely busy these last couple of weeks with some contested hearings. I did get the notice of this, and I have not been able to get it to her, but I would anticipate getting it to her by the end of the day. I'll have some time after lunch to get it done. And I'd hope to get it to her before the hearing so that it'd be moot, Judge. But I'll be honest, and I apologize to counsel. I was almost too embarrassed to call just because it hadn't been done the last time, and I don't know what happened, Your Honor. But I can get it to her before the end of the day, and I'd ask the court to maybe not rule on it until the end of the day, and then as long as it's taken care of, it would be moot, Judge.
Okay. Yes, Ms. Logan?
Yes, Your Honor, that's fine. And I think we have an order on file for within 10 days for him to respond. If you wouldn't mind, at the end of the day, sign that. If or tomorrow, I can let you know whether I let the court.
Well, if I sign it today, we'll give it like 10 days, but I hope he can do that today, like you said. But I've heard a lot of lawyers with the same situation. They need staff. I've heard that. So,
and Mr. Ramirez, if I may, don't ever be embarrassed to call. That's we all work together. We all understand. We're all on the same deal here. So don't worry about it. It's nothing personal at all.
Thank you so much. That means a lot to me.
Of course.
All right. Thank you all very much. You all may be excused. You all have a great day. Bye-bye.
Thank you, Judge.
Thank you, Judge.
Bye.
Yes, ma'am. Bye-bye. Number 6. And that's going to be who now?
Anthony Garcia.
All right, Mr. Anthony Garcia.
Good morning, Your Honor.
Yes, sir. Good morning. You're here on a default hearing, CL 21-1688D, Security First Federal Credit Union versus Maria Orozco Aguilera and Rafael Aguilera. Is this default hearing as to both defendants?
Yes, Your Honor.
As to both? All right. Court will take note that Maria Aguilera and Rafael Aguilera are not in the waiting room. Therefore, court will take judicial notice of the entire file, and you may proceed.
Yes, excuse me. The plaintiff is requesting a judgment on a breach of contract in the amount of $23,889.18, plus pre and post judgment interest, court costs, and attorney's fees. As you mentioned, the defendants did take out an auto loan with the plaintiff in 2019. It was to acquire a 2019 Nissan Titan. The loan was in the original amount of $49,396.25 with an interest rate of 6.99%. The defendants stopped making their payments in early 2020. The defendants failed to cure any deficiencies, and after sending notices to the defendants, the plaintiff repossessed the vehicle and sold it at a private auction. After applying the proceeds from the sale of that, that auction, there still remained a deficiency in the amount of $23,889.18, plus the pre-judgment interest at the contractual rate of 6.99%. The defendants did not file a response, and they have not contacted either our office or the credit union directly to make any settlement offers. Therefore, the plaintiff is requesting that the court grant a judgment today for the full amount of the deficiency in the amount of $23,889.18, plus pre and post judgment interest, court costs, and attorney's fees.
All right. And as far as attorney's fees, did you submit an affidavit?
Yes.
Okay. Okay. All right, then court will go ahead and grant default judgment in favor of plaintiff. Court will grant plaintiff all relief requested here in open court or in its petition. Court will await a default judgment for signature. Anything else, Mr. Garcia?
Nothing further, Your Honor.
All right, sir. You may be excused. Have a great day. Thank you, sir.
You too.
Yes, bye-bye.
Mr. Benz has number 3 and number 4.
Number 3 and number 4, Mr. Benz.
Good morning, Your Honor.
Yes, sir. Good morning. Yes, sir. Good morning, sir. Court will continue here with the February 9, 2022 docket. And we have CL 196499, the Discover Bank versus Robert Valdez.
Yes, sir.
All right. You may proceed on that one.
Good morning, Your Honor. Travis Spence, with the court's permission, appearing on behalf of lead counsel in this matter, Your Honor. Your Honor, I respectfully request the court take judicial notice of any and all documents in the court's file. Your Honor, this is a case in which credit was extended by the plaintiff to the defendant. Defendant utilized such credit. Time to pay came due. Payment was not made. Demand was made. Demand was not met. Defendant was in fact served pursuant to the Texas Rules of Civil Procedure. There is no answer on the file. This matter is ripe for a default judgment in the amount of $9,854.23. Post-judgment interest per annum at a rate of 5%. And cost of court of $370.15.
All right, court will once again take judicial notice of the entire file in the case of Discover Bank versus Robert Valdez in cause number CL 196499D. Court will hereby grant plaintiff all relief requested here in open court. Will grant default judgment for plaintiff and relief as requested here in open court or in his petition. Court will await for a default judgment for signature. In the second one you have, Mr. Benz, is CL 211381, the American Express National Bank versus Mark Minton, aka Mark A. Minton.
That's correct, Your Honor. Your Honor,
You may proceed.
Oh, I apologize, Your Honor. Your Honor, I asked the court allow me to appear on behalf of lead counsel in this matter, Your Honor. I also asked the court to take judicial notice in any and all documents in the court's file. Your Honor, this is a case in which credit was extended by the plaintiff to the defendant. Defendant utilized such credit. Time to pay came due. Payment was not made. Demand was made. Demand was not met. Defendant was in fact served pursuant to the Texas Rules of Civil Procedure. There is no answer on the file. This matter is ripe for a default judgment. My client seeking an amount of $10,776.34 and cost of court, Your Honor.
All right, court will take judicial notice of the entire file in CL 211381D, American Express National Bank versus Mark Minton, aka Mark A. Minton. Court will hereby grant default judgment in favor of plaintiff. Court will grant plaintiff all relief requested here in open court or in his petition. Court will await a default judgment for signature. Anything else, Mr. Benz?
Your Honor, that concludes my business for this honorable court. I appreciate the court taking these matters up. May I be excused?
You're excused. Have a great day, sir. Thank you very much.
Y'all be safe.
You too. Bye.
But Mr.
McLaughlin, right?
I don't know if he's here for 1 and 2.
Okay, I'll ask.
Bank of America.
All right. All right, Mr. McLaughlin. All right, good morning, Mr. McLaughlin.
Good morning, sir.
Yes, sir. For today's cases, do you have 2 of them? Do you have the Bank of America?
I am here on Bank of America. Yes.
Oh, okay. I see two of them on the docket here. I have here CL 180579D, Bank of America NA versus Javier Valadez.
In this case, Your Honor, we believe that Mr. Valdez had opened up a Bank of America credit card in October of 2005. He made his last payment on November 6th of 2016. The account was closed and charged off with a balance of $8,280.97. We're seeking that amount in damages plus costs to the court and would ask the court to take notice of the business records and non-military declaration, certificate of last known address, and issue judgment for the plaintiff.
All right, court will hereby take judicial notice of the entire file in cause number CL 180579D, Bank of America NA versus Javier Valadez. Court will note that the defendant's name is not in the waiting room. Court will hereby grant default judgment in favor of plaintiff. Court will grant plaintiff all relief request a hearing open court or in this petition. Court will await a default judgment for signature. Then the second case, CL 184550D, Bank of America NA versus Artemio Ramirez. Court will note that Ramirez is not in the waiting room. You may proceed, sir.
In this case, Your Honor, we believe that the defendant had opened a Bank of America credit card on June 26th of 2002. He made his last payment on January 26th of 2016. The account was closed and charged off with a balance of $12,780.06, and we're seeking that amount in damages plus costs of the court, and would ask the court to take notice of the business records, the non-military declaration, certificate of last known address, and issue judgment for the plaintiff.
All right, court will take judicial notice of the entire file in CL 184550D in the case of Bank of America NA versus Artemio Ramirez. Court will hereby grant default judgment in favor of plaintiff. Court will grant plaintiff all relief request a hearing in open court or in this petition. Court will await a default judgment for signature. And I think that'll do it, right, sir?
Yes, sir. Thank you.
All right, thank you. Have a great day. Your excuse.
You too, sir.
Bye-bye. You want to bring in Magda? Okay. How about Magda Gutierrez? She needs to unmute.
It's on
There she is. Can you hear me, ma'am?
very far away.
Can you hear me now? I can hear you loud and clear.
Okay.
You're here on P0362-20-4, Magda Gutierrez versus Joe Daniel Berrones. And it is my understanding that the attorneys for this case have asked that we take no action today. It's being passed for another hearing date. I'm sorry? Just made an extension file. Did you get that, man?
Okay, so contact Mr. Doherty for the new date.
Okay. Did you hear me?
Yeah, that there was a judge.
There's an extension. Talk to your attorney, Joe Garcia. He'll explain to you.
Garcia.
Yes. He'll explain to you. Nothing happened today. We have an extension.
There's
All right.
an extension. Okay.
Yes, ma'am. Thank you so much. Your excuse. Have a good day.
I appreciate it.
Bye-bye.
We have pro se litigant, Mr. Joaquin Alfaro, number 7, but Mr. Joe Hernandez is not here to.
There's no action. Okay. All right, I understand that Joaquin Alfaro is trying to connect. Rick, do you have his phone number?
Yes, sir, I do.
Okay, Mr. Alfaro is trying to connect. I don't know if he's going to be successful or not. You might want to just call him and tell him that the attorney, the opposing counsel, Joe Hernandez, has not checked in. So as far as today, no action.
Yes, sir, Judge. I'll give him a call.
No action, but tell him that try to work out the case with the other party. Okay.
Will do. Yes, sir.
But for today, no action. Joe Hernandez, the other attorney, did not show up. Okay.
Yes, sir.
Okay. Thank you.